Welcome to the deep dive. You know, when we talk about conflict at work, it's easy to get bogged down in the policies and the legal speak.
Hmm.
But often, what's really going on is this deeply personal struggle, isn't it? An employee up against, well, a pretty powerful organization.
That's exactly right. And that power imbalance, that's what we're really getting into today. We're doing a deep dive into how these workplace disputes actually play out in Australia.
Right.
And we're using some fascinating sources here from the Australian Workplace Discrimination Representatives, or AWDR. These are specialist reps, not lawyers, mind you, but they've been in this field for over 30 years.
Over 30 years. Wow. So our mission today is really to get under the hood of Australia's Fair Work Act, equal opportunity laws, understand what happens when you actually try to enforce your rights.
Yeah, we're moving past the theory. We want to look at the real strategies, the common problems, drawing on insights from, believe it or not, over 16,000 client cases they've handled.
16,000, that's huge.
And it includes a couple of really eye-opening cases involving HR managers themselves acting improperly.
Okay, so this is really for anyone who wants to know, what are my rights? And crucially, where's that line? When does a company decision cross over into being unlawful?
Exactly. Where does legitimate management stop and illegal adverse action start? And because AWDR covers all of Australia, we're getting a pretty broad picture here.
All right, let's dive in then. When someone first realizes, okay, I need help here, what kind of situations are these specialists typically seeing? It sounds like it's more than just being fired unfairly.
Oh, definitely. It's quite a spectrum of issues, really. Unfair dismissal is sort of the baseline, you could say.
Okay.
But the really complex stuff often involves general protection disputes, sexual harassment claims, workplace bullying, dealing with a toxic workplace environment.
Toxic workplaces, right? That seems more common now.
It does. And also non-genuine redundancy,
Right.
where the redundancy isn't quite real in that legally tricky area of adverse action.
That list really shows how tangled up your work life and your legal rights can become. Can we maybe pin down some key terms? Like, what's the real difference between, say, unfair dismissal and this general protection or adverse action thing?
Good question. Let's break it down. So unfair dismissal, generally speaking, is about fairness in the process.
Yeah.
Maybe you were let go without a really solid reason, or maybe the reason was okay, but your employer just didn't follow the right steps.
They didn't tick the boxes, maybe didn't give warnings.
Exactly. They dismissed you.
Yeah.
Badly, you might say. Now, general protection disputes, which involve adverse action, that's a different beast strategically.
How so?
This is where it shifts from how you were fired to why. Adverse action is when your employer takes negative action against you, could be firing you, demoting you, even giving you bad reviews.
Okay.
Because you exercised a workplace right. Like maybe you asked about your pay, or you joined a union, or you made a safety complaint.
Okay, so if I complain about safety and then I get fired, I might have an adverse action claim.
Precisely. And here's the kicker, the really crucial strategic point. If you make an adverse action claim, the burden of proof actually flips.
Really? How does that work?
Yes. The employer then has to prove that the action they took, the dismissal, whatever it was not motivated, even in part by you exercising your right.
Wow, so they have to prove they didn't retaliate. That sounds incredibly powerful.
It makes these claims potentially much stronger in certain situations. It changes the whole dynamic of the fight.
Okay, that's clear. And the third one you mentioned was constructive dismissal, being forced out.
Right. That's when things get so bad, so toxic, often deliberately made that way by the employer, that you feel you have absolutely no choice but to resign.
So you quit, but legally.
Legally, it's treated as if they unlawfully dismissed you. And that's where these specialists come in, providing representation, helping with mediation, negotiation, trying to get some justice, often compensation. They sometimes do no-win, no-fee for unfair dismissal or sexual harassment cases, too.
Okay, so we have the landscape, the tools, let's see them in action. You mentioned a case that really highlights this retaliation risk when an employee just asks about pay. Noskovsky v. Hisense.
Yes, this is a classic adverse action scenario. Philip Noskovsky, he was a customer service team coach. All he did was repeatedly ask about his pay specifically, casual loading and shift allowances he thought he was missing, starting back in 2019.
Just exercising a basic right to query his pay.
Exactly, his right to understand his terms and conditions. Then a new HR manager, Rand's son, comes on board.
And things change.
Well, Noskovsky finally gets the underpayment paid over $12,000. But, and this is telling, Ms. Sun pushed the payment through before providing the documents he'd asked for to check it.
Sounds like trying to shut the issue down quickly and maybe avoid scrutiny.
It certainly looks that way. And the situation went downhill fast. Soon after, Noskovsky's own manager was fired over a massive internal fraud.
Okay, so there's chaos already.
Right. And Noskovsky's promised promotion, suddenly withdrawn. Then, when he kept asking for the records about his pay, Miss Sun just wouldn't provide them.
So, stonewalling first, but then it escalated.
It did. She didn't just ignore him, she went on the attack.
Wait.
Miss Sun actually demanded Noskovsky prove his legal right to work in Australia.
What, after he'd been working there?
Yes, and threatened further actions. It feels like a clear attempt to intimidate him, to make him drop the pay issue.
That's incredibly aggressive.
And it didn't stop there. When Noskovsky ended up on sick leave, suffering from stress and anxiety from all this,
Understandable.
he asked to use some annual leave. Miss Sun refused, saying it was the busy season. Then she threatened to put him on unpaid leave when his sick leave ran out. Just really turning the screws.
So eventually they dismissed him. What was the official reason?
They claimed he refused to attend a welfare meeting and a medical assessment. But Noskovsky's argument was basically, you're just using this internal fraud mess as cover to punish me for asking about my pay.
Putting the blowtorch to him, as he put it. So what did the court say?
The Federal Circuit and Family Court sided with Noskovsky. They found his sentence did breach the Fair Work Act by not giving him the records. And importantly, they confirmed he was underpaid because he'd been misclassified.
And the HR manager's conduct, how did the court view that?
This is key. The court found Mrs. Sun's evidence unreliable. Her refusal of his annual leave, described as cold-hearted.
Cold-hearted, strong words from a court.
Very. They said her whole approach was high-handed, dismissive, and at times retaliatory. The final ruling was clear. His hands took unlawful adverse action against him because he pursued his workplace rights. He was unlawfully dismissed.
So the big takeaway there seems to be, if an employer acts in that high-handed, retaliatory way just because you asked about something you're legally entitled to ask about, the law can protect you.
Absolutely. That protection for exercising your right is powerful, even when facing a big company trying to find another excuse.
Okay. That case shows the system protecting an employee. But you mentioned another case that shows the flip side, accountability, when an employee, especially someone in HR, acts dishonestly.
Exactly. It shows the necessary balance. We need protection, but we also need accountability for serious misconduct. This next case, Firas Rakib v. Stantec, Australia, PILED, is quite something.
And the alleged misconduct came from a senior HR business partner.
That's what makes it so shocking.
Yeah.
Rakib was facing multiple complaints, things like inappropriate comments, not maintaining professional boundaries, and even coercive control over a female colleague he supervised.
Coercive control? That sounds serious.
Very. Plus, there was another allegation of inappropriate touching at a work Christmas party, so serious stuff.
Okay, so he's facing dismissal for all this. What did he do?
Well, this is where it gets elaborate. His legal representative submitted what they claimed was evidence, a screenshot of a text message.
A text message? From who?
Supposedly, from the main complainant, Mrs. Winsbury. The text allegedly had her apologizing, saying she'd been talked into making the complaint against him.
Ah, trying to undermine the complaint itself.
A very risky move. Because Stantec investigated it thoroughly, and they found the text message. It was, quote, a complete fiction.
Fake. How?
Reggie had sent the message to himself, from his work phone to his personal phone, making it look like it came from her.
No way. He sent it to himself.
Yes. His explanation was that Mrs. Winsbury must have somehow grabbed his work phone after she'd already resigned and left the company just to send that text to his personal phone.
That sounds extremely unlikely.
The Fair Work Commission thought so too. They called his story a smokescreen and a cynical fabrication.
A cynical fabrication. Wow. So the FWC saw right through it. What else did they say?
They were pretty scathing. They found Rakib an unimpressive witness. His criticisms of his female colleagues were labeled disgraceful and actually misogynistic.
Misogynistic. That's damning.
Absolutely. So the FWC found there were valid reasons for his dismissal on two main grounds. One, he tried to contact a complainant, breaching confidentiality directives.
Okay.
And two, the fabricated text message. The commission even said his story was something the spy novelist John le Carré would have been impressed by.
Good grief. A spy novel plot cooked up by an HR partner. But didn't you say there was a procedural issue with how Stantec dismissed him?
Yes, and this is important for listeners to understand. The FWC did note that Stantec made some procedural errors. They hadn't formally told Rocky these exact two reasons, the contact breach and the text fabrication, before they fired him.
Ah, so a potential slip-up by the company. Did that save him?
No, and this is the crucial point. The FWC ruled that Rakib's misconduct, the underlying behavior, the misogyny, and especially that deliberate, cynical fabrication of evidence was so severe that it comfortably outweighed any procedural flaws by Stantec.
So the sheer gravity of his actions trumped the company's procedural mistakes.
Precisely. His unfair dismissal claim was thrown out.
It really paints a picture of two sides of the coin, doesn't it? The Naskoski case shows the system stepping up to protect employees exercising legitimate rights against retaliatory managers.
Yes, even when they're cold-hearted or high-handed.
But the Rahib case shows the system also has teeth to deal with serious dishonesty and misconduct, even from senior people, and even if the employer's process wasn't perfect.
Exactly right. It highlights the complexity. You need that expert help to figure out the strategy, the evidence. Because as Rekid found out, if you're fundamentally dishonest, procedural arguments might not save you.
And underpinning both stories is the very real human cost, isn't it? A toxic workplace, a contested dismissal.
Yeah.
It takes a massive toll on people's lives, their careers, their well-being.
Absolutely. That's why these specialists exist, to try and navigate that power imbalance, build a case, and aim for some form of justice or compensation.
Right. So thinking about these two cases, the HR manager retaliating, the HR partner fabricating evidence, it leads to a really interesting final thought, doesn't it?
It does. The FWC called Rahib's fake text a story worthy of Le Carré, a spy novel plot.
Yeah.
So the provocative question for you listening is this. If manipulation can happen at that level, within HR itself, what level of care, what kind of documentation, what vigilance should you maintain in your everyday work interactions, your emails, your meeting notes, your requests? How carefully should you be tracking things to protect yourself if things go wrong, or just to make sure your own record is crystal clear if you ever face scrutiny?
That is definitely something we're thinking about. Thanks for taking this deep dive with us today.